Hello everyone and welcome back to our channel. My name is AYUSH Kumar Singh. I am a legal intern in LEXIS and Company. So today we are going to take an overview on Industrial Dispute Act 1947. According to the definition, the industrial dispute means any dispute or difference between employer and employee, employer and workman, or workman and workman which is connected with. Industrial dispute may be said to be disagreement on or controversy between management and labor with respect to wage, work condition, and other employment matters or union recognition. So now moving towards industry. As per section 2J of Industrial Dispute Act 1947, industry means any systematic activity carried on by cooperation between an employer or and his workmen for the production of supply or distribution of goods and services, which in view to satisfy human want or human needs. So now let's see different types of industrial disputes. The first one is internal disputes which arise due to the deadlock in negotiation for collective bargaining. Second one is unfair labor practice. Those arise out because of the violation or violation of failure of implementation or ill treatment or illegal strikes by the labor class. Third one is grievance dispute. This may pretend to discipline, wages, working time, promotion, right of supervisor, etc. And the fourth one is recognition dispute. This is because of this is over the right of an trade union to be represented to represent class or category of workmen. So now moving on authorities. Any person who is workman employed in an industry can rise an industrial dispute. Workmen include any person employed in an industry to do manual, skilled or unskilled, technical, operational, or supervisory work for hired or rewarded. It excludes those employees in managerial and administrative capacity. Industry means any business, trade union, manufacture and include any service, employed, handcraft or industrial occupation of workmen. Now let's see prohibition of strike and lockouts. According to section 22 clause 1, no person employed in an with a public utility service shall go on strike in breach of contract without giving the employer notice of strike within 6 weeks before the strike, before the strike of the date specific in such notice. And according to section 23, no employee of any industrial establishment shall go on strike during the period when proceeding in any disputed case is going on or where final judgment is awaited. Now the next topic is settlement without state intervention. There are basically two ways in which parties to an industrial dispute, the employer and the employee, can settle their dispute. First is collective bargaining and second is voluntary arbitration. Now let's see what comes under settlement under the influence of the state. First one is compulsory establishment of bi-party committee. Second, establishment of compulsory collective bargaining. Third, counsel and mediation. Fourth, compulsory investigation. And fifth, compulsory arbitration and adjudication. Now let's take an overview on voluntary arbitration. It is commonly viewed as the less expensive and fastest resolving dispute in the court. An arbitrator may be single person or a plaintiff. Sometimes, however, the parties may agree to submit the dispute to an arbitrator, but at the same time reserve their right to accept or reject the award when it comes.